Common Law, presented by Andrew Ramsey for Business Law 2. Common Law. Common law is the ancient law of England that is based upon the societal customs of the people, which is recognized and enforced by the judgments and the decrees of the court. Common law. Continue. Common law courts base their decisions on prior judicial pronouncements rather than on legislative enactments. In a legislative enactment, we would see that a statute would govern the dispute, and the judicial interpretation of that dispute would determine how the law applies. While in common law, the judges would rely on their predecessors' rulings on actual controversies rather than on abstract codes to guide them in their decisions. These decisions the judges use to help them decide what to do are found in a law report which contains decisions from previous cases which follow the doctrine of stare decisis. An example of each of these would be in common law, is where a person, say, walks down the street and is shot in a local drive-by, and the person is caught and apprehended and is then sent to court. He gets a verdict from the judge for life without parole. And then we see 2 weeks later the same incident happen, not on the same street but in the same neighborhood by a different fellow, and another person is killed. They would look at the previous decision and more than likely they would use it to follow with their reasoning that this second person would be sentenced to life without parole also. While in a legislative enactment, we would see a law broken, and under the statute it would tell you if this was done, you would get this punishment. If this, and this were also done while under this statute, you would get a longer or lesser punishment depending upon the actual crime. Stare decisis. Stare decisis is where common law judges are obliged to go along with the previous decided case, better known as precedent, where the facts are, for the most part, the same. A court decision is a binding authority for all similar cases that are decided by the same court or by courts that are lower than it within the same jurisdiction. However, though, the decision is not binding to the courts that have a higher rank within that jurisdiction or in other jurisdictions. However, it can be considered as persuasive authority. So basically what this means is that, say, a court here in Clovis rules on something, and we see the same court come up in Portales. They would not have to follow the same decision that was made because they're not in the same jurisdiction. However, say the Supreme Court rules on something like the Second Amendment, and they say that everyone has the right to bear arms regardless of a criminal history. With this, all courts would have to allow the selling of arms to people with a criminal past. Yes, it's not happened, but that is just an example of what could happen. Since they are a higher court, all courts below them would have to follow because all follow the precedents that the Supreme Court sets. Common law. The common law system prevails mainly in England and the United States and other countries that were settled by England. Common law is used in all of the United States except for Louisiana, which is where French civil law and the English common law are mixed together to form a hybrid system. History of common law. Anglo-American common law can trace its roots all the way back to the medieval idea that the law, as handed down from the king's courts, represent the common customs of the people he ruled over. It mainly evolved, for the most part, from the three English crown courts from the 12th and 13th century, which were the Esquire and the King's Bench, and lastly the Common Pleas. These courts would eventually assume jurisdiction over the disputes that had previously been decided by the local or manorial courts. History of common law continued. Early common law procedures was ruled over by a complex system of pleading under which the offenses that were written into authorized writs were allowed to be litigated. All complaints had to satisfy all parts of the writs before they were allowed to gain access to the common law court. The system that replaced this in the United States and England in the mid-1800s was called the Code of Pleading, which was a simpler form of pleading. Code pleading only required a simple, plain statement from the parties and left determining the issue at hand to the courts. So basically, the main difference between pleading and code pleading was that code pleading, you didn't actually have to fall under all parts of the writ as long as there was something wrong done. You would submit your side of the story and the other person would go ahead and submit their part of the story, and the court would then go ahead and decide what the fate was going to be. However, in the first part we talked about, we see that we have to have everything satisfy all parts of the writs before you even allowed to go to the common law courts, which even though you were just going didn't mean you had to get a decision or even a ruling on what happened. American Constitution. This in itself could be considered a form of common law that we brought to the United States. The United States Constitution is a great example of the common law in America. Our founding fathers set forth a set of rules that was going to govern a nation. These laws would become what we call as common law today. Along with the Constitution, they set forth a set of new rules called the Bill of Rights. This Constitution at the time was going to set forth the rules that were going to govern everyone based on the customs that they wanted to bring to America away from the oppression of the king in Britain. An example of this would be our Second Amendment, the right to bear arms. This was in the Bill of Rights. The Second Amendment allows us the right to bear arms. The law has been in place since the Bill of Rights was ratified in December 15, 1791. The right to bear arms has become a common law in America, even with more sanctions that have been put onto the right of people to buy these arms. The term constitutional right is for the most part the same as a common law. Common law is a set of rules set down based on the customs of the country, while the constitutional rights given to the American people in the Bill of Rights are the natural rights and the founding fathers said we had. So basically, the Second Amendment is protecting what the founding fathers said we should be able to have because that's what they thought was right. It was going to be the customs in America. Another example of this was the freedom of press. The freedom of press is where the press has the constitutional right to report on anything they want and not have to give up their sources. Over time, this has also become a form of common law because we have seen it in our customs along with it being a constitutional right. We cannot just go up to a reporter and tell them they're not going to be able to report on something because the government doesn't want them to, or a news agency doesn't want them to. If a reporter wants to report on a subject, that is their constitutional right and is a common law issue. It has been set forth over time, and it has been ruled on over and over that the press has the right to talk about whatever they want because it's their constitutional right or their common law rights. Common law. Common law is more than just a set of rules that are set down by the judges. They are a set of customs that are used to determine how we rule on cases, and as we rule based on customs, we set precedent. With this precedent, we make it easier for the judges in the future to rule on a case that has already been ruled on, allowing for stare decisis to set in. Thank you for listening, and have a great day.